All right. Hi, everyone. We're going to go ahead and get started. Good morning again to those of you on the West Coast. Good afternoon to those of you on the East Coast. Thank you so much for joining us today to talk about the Department of Homeland Security's recently finalized public charge rule. My name is Rebecca Ulrich, and I'm a policy analyst on the Child Care and Early Education team at the Center for Law and Social Policy, or CLASP. I'm here with my colleague, Renato Roca, a policy analyst on the Income and Work Supports team as well. For those of you who aren't familiar with us, CLASP is a national, nonpartisan, anti-poverty organization located in Washington, D.C. We work across a number of policy areas, from child care and early education, public benefit access, high-quality jobs, and more. We are also the proud co-conveners of the Protecting Immigrant Families, or PIP campaign with the National Immigration Law Center. Before providing an overview of what we're going to cover today, I just want to go over a few housekeeping items. First, all participants are in listen-only mode. If you have a question, please submit it in the chat box. The webinar is being recorded and will be posted to our website within the next week or so. We'll share a link to the recording as well as any related resources mentioned during the webinar to everyone who registered. Next slide, please. Today we are going to take a deeper dive into the Department of Homeland Security's final rule on public charge. We'll provide an overview of public charge policy and how it changes under the final rule, and answer some of the commonly asked questions we've received about how the final rule affects families with young children. We'll discuss what you can do as a service provider, advocate, or policymaker to combat the chilling effect, including how to talk to families about the final rule. Please submit your questions in the chat box, and we will do our best to answer them in the Q&A. Next slide. I also want to be upfront about what this webinar will not cover. We will not be talking through changes to the Foreign Affairs Manual or consular processing, which govern the process by which immigrants apply to enter the U.S. from outside the country, or the different pathways through which immigrants may adjust their status once they're living in the United States. We also won't talk in specific detail about eligibility requirements for various state or federal programs. We will include some resources that will hopefully answer your questions on these topics when we share the webinar recording. We will also be unable to answer specific questions about a particular client or family. All of the information that we're sharing here is based on CLASP, NILC, and the PIP campaign's analysis of the public charge final rule. It does not constitute legal advice. We recommend that you connect families to an immigration lawyer to answer specific questions about their circumstances. If you have any other questions that we don't answer on the webinar today, please don't hesitate to email Renato or me. We'll share our contact information at the end of the webinar. Now, I'll turn it over to Renato to give an overview of the public charge final rule. Next slide.
Hi, everyone. This is Renato Rocha. I think the line went out, so I just want to make sure, can folks hear me? Can you type in that you are able to hear me at this point? Hi, everyone. This is Renato. Sorry for that technical issue with the audio. So first, you'll hear about what public charge looks like today. Then we'll explore why the final regulation is such a radical change. Next slide, please. The public charge determination asks the question, is the person likely to become primarily dependent on government for their primary source of support? So when a non-U.S. citizen applies for a visa to enter the U.S. or for a lawful permanent resident status to get a green card, a U.S. government official will look at that person's life circumstances to see if the person is likely to depend on government programs in the future. If they are, they can't be admitted and can't become a green card holder. Under long-standing guidance, the public charge determination has been limited to an evaluation of dependence on two categories of benefits: cash assistance like TANF and SSI, and long-term care at government expense. Other types of public benefit programs have been specifically excluded, and because of this narrow definition, there have been practically very few denials on the basis of public charge. This means that immigrants and their families could participate in programs for which they're eligible without fear that accessing programs like Medicaid or housing assistance would have negative consequences for their immigration status. Next slide, please. Since early 2017, it's been clear that the Trump administration wants to expand the types of benefits which can be considered in the public charge determination. In January 2017, the first sign of this threat was an executive order that was leaked to the media but was never signed or issued. Then, more than a year later, on October 10, 2018, DHS published the NPRM for a 60-day comment period. On December 10th, that was the last day of the comment period when more than 266,000 comments were submitted on the proposed regulation. We were then in a waiting period when DHS had to review and address all the comments in the rule. In July 2019, just a couple months ago, was when the final rule went to OMB for final review. And on Wednesday, August 14th, a final rule was posted to the Federal Register. And now we are in a 60-day period before the rule is scheduled to go into effect. And until a final rule is in effect, USCIS will continue to apply the current narrower public charge policy. Next slide, please. So who does public charge apply to? Public charge comes up in two main ways: when an individual is seeking to enter the U.S. with a visa, or when applying for a green card or legal permanent residence LPR status. Keep in mind that some individuals living in the U.S. have to leave the U.S. and return to their country of origin to get a green card. And also really important to remember that there is no public charge test when a green card holder applies to become a naturalized U.S. citizen. However, if a green card holder leaves the U.S. for more than 6 months and re-enters, this may trigger a public charge test. There are also certain categories of immigrants, including refugees and asylees, that public charge does not apply to. Next slide, please. So now we're going to get into some of the specifics about the public charge test today. So the public charge determination is based on an assessment of all relevant factors, and this is known as the totality of circumstances test. And by law, an officer must look at all of an applicant's circumstances, including age, health, family status, financial status, education and skills, and the affidavit of support. And this affidavit of support is a contract that a sponsor, usually a family member, signs to accept financial responsibility for an individual who is moving permanently to the U.S. In practice, if there is an issue with one of the factors or benefits use, they look to an affidavit of support. The decision is also forward-looking and can't be based only on what happened in the past. So the fact that someone just graduated from school or has a job offer can balance past use of benefits if their situation has changed. Also, no single factor alone can determine whether someone is deemed to be a public charge. Next slide, please. So here are 3 buckets of changes that we've identified in the final rule that are organized into these 3 buckets. The first is a dramatically different definition of public charge. Next, the factors I mentioned in the totality of circumstances test, age, health, family status, income, education, and skills, are given weight that makes it harder for low and moderate income people to pass. Finally, at the end here on the right, the final rule would include additional benefit programs that can be considered by immigration officials. Next slide. So now we'll go into a bit more detail into each of these three buckets of changes. So first is here the new expanded definition of public charge. It moves from likely to become primarily dependent on government for subsistence to a person who is more likely than not to receive one or more of the specified benefits for over 12 months in a 36-month period. Next slide. The boxes here to the left represent the totality of circumstances test that I just mentioned a bit ago. The final rule adds criteria for each of these elements, and the net effect really is that it creates lots more ways for people to fail the public charge test. For age, for instance, the rule lays out that being too young or too old, specifically under age 18 or over age 61, would be weighed negatively. Being prime working age, so 18 to 60 years of age, would be weighed positively. Income and financial status, the rule weighs low incomes negatively, also reviews immigrants' credit history and credit score, among other factors. Under health, it weighs negatively whether the non-citizen has health conditions that could require extensive treatment in the future or that could affect the person's ability to work, attend school, or care for oneself. Under education and skill, the factors include English language proficiency and employment history. Household size is taken into account under family status. And for the affidavit of support, it looks at the relationship of sponsor to the immigrant and whether they live together. Next slide. So in addition to these factors, there are also heavily weighed negative and heavily weighed positive factors in the final rule. So heavily weighed negative factors on the right side of the scale include diagnosis of a medical condition that is likely to require extensive treatment or will interfere with the ability to work, attend school, or provide care for oneself, and that the immigrant does not have private health insurance or other resources to pay for treatment. Another negatively weighed factor, heavily weighed negative factor, is lack of job or no prospect for future work. And another one is receipt of public benefits for more than 12 months in a 36-month period. Heavily weighed positive factors include household assets and resources of at least 250% of the federal poverty level. Next slide, please. And that last bucket of changes in the final rule is that the final rule adds additional programs in the public charge determination. In addition to cash assistance and long-term care at government expense under current policy, which are those two red boxes to the left, it would include supplemental nutrition assistance programs, SNAP, federal, state, local, and tribal cash assistance, Medicaid with exceptions, housing assistance, public housing or Section 8 housing vouchers, and rental assistance specifically. And it's also really important to note that the Medicaid exceptions included are for emergency medical conditions and coverage of children under 21 years of age and pregnant women. Next slide, please. One really important note is to stress that other than cash or long-term care benefits paid for by government, benefits used before the rule is effective will not be considered in the public charge determination. Next slide. Another important thing to keep in mind is that public benefits not specifically named in the rule are not considered, including Head Start, child care assistance, WIC, CHIP, school breakfast and lunch, energy assistance, to name a few on the list here in front of you. Next slide, please. And now I'll quickly share with you some high-level information about who would be harmed. Some people would be directly impacted by the rule because they're applying for a green card within the U.S., for example. Other people would not be directly impacted because they are naturalized citizens or are exempt as refugees, but may disenroll a U.S. citizen child, for instance, from Medicaid or SNAP out of fear or confusion. These indirect impacts are called chilling effects, and experts anticipate a significant chilling effect. An estimated 26 million people would be impacted according to research from MinetHealth, and this number represents individuals and family members with at least one non-citizen in the household and who live in households with earned incomes under 250% of the poverty level. And of the potentially impacted population, approximately 9 million are children. Next slide, please. And the fight isn't over. One important note here is that it's important to keep in mind, and we'll mention this a few times today, the current public charge test is still in place until the final rule goes into effect on October 15th. I'll also note that the final rule is already being litigated in the courts, with several lawsuits, 6 so far, challenging the rule in place. So I'll now pass it back to Becca to talk about specifically the implications of the final rule with immigrant families with young children.
Thanks, Renato. So now we're going to walk through some frequently asked questions about how immigrant families with young children may be affected by changes to public charge policy. I wanted to thank all of you who submitted questions when you registered. That was incredibly helpful for us in developing both this webinar as well as an upcoming resource that we'll be publishing here soon and that I'll mention a little bit later in more detail. So as a reminder, you can continue to submit your questions in the chat box. And this webinar is being recorded and we will share it with all of you within the next week or so. Next slide, please. So many of you wanted to better understand exactly who the changes to public charge policy apply to, which is a really great question because it's confusing. So it's very likely that the families you work with include members with different immigration statuses. So the vast majority of young children, specifically those who are under the age of 6, who are members of immigrant families, are themselves U.S. citizens. Other family members in the household might be naturalized citizens, here on a temporary or permanent visa, green card holders, or they may be undocumented. In two-parent households, you may have parents you may have families where each parent has a different immigration status. And so the public charge rule is going to have different implications for different family members. The changes to public charge policy only have implications for immigrants who may apply for a green card in the future from within the United States. And that's because the changes were from within the Department of Homeland Security. Now, since most young children in immigrant families are U.S. citizens, you'll mostly encounter families in which the parent, or perhaps an older sibling, hopes to get a green card in the future. And those are the members of the family that would need to have additional consideration given as to how public charge might affect them. If the parents or children you work with are U.S. citizens, current green card holders, or are refugees, asylees, or have another form of protected status, public charge does not apply. The public charge process for immigrants applying to enter the United States from abroad is governed by a separate set of policies in the Foreign Affairs Manual, or FAM, which we aren't going to go into detail on today. Policies in the FAM also have implications for immigrants who might wish to sponsor a spouse, parent, or other family member to come to the U.S. If you want to learn more about changes to the FAM, you can check out this resource on the slide from NOC. It should be linked in the slide, but we'll also include it in our follow-up email within the next few days. Next slide, please. We also got a lot of questions about whether the public charge final rule had implications for U.S. citizen children's ability to access public programs and services. The answer to that is no. Public charge does not apply to U.S. citizens, and any benefits that children use will not factor into their parents' public charge determination. The rules governing eligibility for public programs and services remain unchanged, and citizen children are generally eligible for any public benefit program. You should encourage parents to keep their children enrolled in benefit programs for which they are eligible, including SNAP, Medicaid, housing assistance, and other public programs and services. Next slide. So again, if you're working with young children, particularly those under the age of 6, it will be relatively rare that you're working with children who are not U.S. citizens. But the children and families you serve may include older siblings or other children in the household who are non-citizens. So for children who are not citizens and who may apply for a green card in the future, their own use of SNAP, housing assistance, government-funded long-term care, or cash assistance will count against them in their own public charge determination. Medicaid use will not count against children who are under the age of 21. However, it's important to reiterate that public benefit use alone does not automatically make anyone a public charge. Immigration officials will consider the child's totality of circumstances in the public charge determination. And of course, if the child is a green card holder or has a refugee, asylee, or other status afforded to vulnerable populations, a public charge will not apply. Next slide. So several people also had questions about pregnant women and whether the rule would impact access to prenatal care. The final rule states that Medicaid use while pregnant and up to 60 days postpartum will not count in a public charge determination. You should encourage pregnant women to get the care that they and their babies need. Next slide. We got quite a few questions about how the final public charge rule talks about state-funded programs. This answer has two parts. First, use of any cash assistance program, whether it's federally funded or funded entirely by states or tribes, will count negatively in a public charge determination. However, the rule is clear that if a non-cash benefit isn't specifically named in the rule, then it will not be included in a public charge determination. The final rule specifically names the following non-cash benefits: government-funded long-term care, public housing or Section 8 housing vouchers, rental assistance, SNAP, and Medicaid, with exceptions for children and pregnant women. That means that use of any other non-cash benefit, including, for example, state-funded health plans or child care assistance, will not be factored into a public charge determination. Next slide. There is a lot of confusion about the relationship between public charge and program eligibility. It is important to know that public charge is a provision in immigration law, and it has no bearing on immigrant eligibility for publicly funded programs, services, or benefits. This is definitely an area where you're going to get questions from parents, so make sure that staff in your program are aware of the eligibility requirements for different programs. You should also ensure that you are following existing rules and restrictions related to asking questions and collecting data on immigration status. Keep in mind that U.S. citizen children are generally eligible for all state and federal programs and services as long as they meet other eligibility requirements. Next slide. So many immigrant parents who are reluctant to enroll in public benefits for themselves or for their eligible family members have concerns about sharing their personal information with the government. You can assure families that federal and state laws protect the privacy of people who apply for or receive health coverage, nutrition assistance, economic support, early care and education, and other publicly funded programs. Benefit agencies may share the information that they do collect with other government agencies only for the purposes of administering their programs, with very limited exceptions. Applications for public programs should not ask for information about the immigration status of people who are applying to get benefits for another person in their family or the household. This means that if an immigrant parent is applying for benefits on behalf of their U.S. citizen child, they should not have to answer any questions about their own immigration status. If you're helping parents complete application forms for public benefits, you can let them know that they only need to fill out the required fields on an application form. They can refuse to provide any optional information or documentation if they wish. Next slide. All right, so now we're going to talk a little bit about what you can do as an advocate, service provider, or policymaker to combat the chilling effect and to support families in your state or community. Next slide. So an important first step is equipping yourselves and your staff with basic information on public charge so that you can answer families' questions and connect them to resources when necessary. State and local government agency staff should have an understanding of public charge policy, how it changes in the final rule, and how changes to public charge policy affect the programs you provide and the communities that you serve. Staff who work directly with families, including child care resource and referral providers, home visitors, family engagement specialists, enrollment specialists, and others, should be able to answer questions regarding who the public charge test applies to, populations that are exempt from public charge determinations, benefits considered in public charge determinations, updates on the implementation of the final rule, and information on legal assistance hotlines and legal service providers in your community. Next slide. Here are a few questions that frontline staff might get from parents and how you can respond. I'm scared to sign up for WIC. I know that WIC is a public benefit.
A potential answer may be, you're right, WIC is a public benefit, but it is not included in the public charge test. We encourage you to sign up for programs you're eligible for.
I'm pregnant and need help. I'm currently enrolled in Medicaid, but I'm afraid it will be used against me.
The answer? The public charge test will not be considered non-emergency Medicaid used by pregnant women up until 60 days after they give birth. We encourage you to get the health care that you need and that your baby needs.
Coverage under my Medicaid plan is the only option for health insurance for my children who are 5 and 18 years old. My 5-year-old is a U.S. citizen.
Answer: the public charge test has specific exemptions for children under the age of 21 that use Medicaid. Your 18-year-old falls under that exception. Their use of Medicaid will not be considered in their public charge test. The public charge test does not apply to your 5-year-old. Neither child's benefit use will count against you.
Next slide, please. So another step that you can take to combat the chilling effect is to make information on public charge easily accessible and available for families. For example, state and local agencies should have information about public charge available in locations where families apply for or receive services. Early childhood and other direct service providers can include information about public charge in their lobbies or waiting areas, on a resource table, or in information packets sent home to parents. You may also consider having information readily available and accessible that talks about public benefit eligibility requirements, making it very clear which programs families are eligible for. Early childhood providers may also consider hosting consultation sessions with an immigration lawyer so that families can talk about their specific circumstances, or information sessions with a public benefit enrollment specialist so families can ask questions about eligibility and data sharing. Next slide. You can also help families feel safer by reviewing and revising your internal policies and practices. For example, you should ensure that families' private information is recorded and stored in compliance with state and federal laws, and that families have ready access to easy-to-understand information about existing confidentiality protections in multiple languages. State and local government agencies can consider strategies to make their application and enrollment processes more friendly to immigrant families, such as being flexible about how household members prove their income, including through a letter from an employer, self-attestation, or other means if needed. Direct service providers can evaluate their application and enrollment procedures to determine whether such materials ask for information like Social Security numbers or citizenship status, or documentation like birth certificates that aren't necessary to enroll a child or family into the program. Asking for this information, even if it's optional, may deter families from enrolling. If you ask these questions to assess families' eligibility for other programs, consider collecting this information separately from the application and enrollment process for your program. Sequencing these processes can give the family time to get to know you and your program and see you as a trusted resource before they're being asked to share personal information. If you need to collect this kind of sensitive information to determine a child's or family's eligibility for your services, or if you don't have the option to revise your application or enrollment materials for other reasons, consider having a staff member walk parents through the forms step by step. The staff member should explain why the information is being collected, how you will use it, and the protocols you follow to protect families' privacy. Next slide. So we want to continue to document the impact of the public charge rule on families and communities. National enrollment data already show declining enrollment in programs that were named in the rule, including Medicaid and SNAP. Early childhood programs like child care assistance, Head Start, home visiting, and state-funded preschool or pre-K, and other programs families with young children rely on, like CHIP and WIC, are not directly affected by changes to public charge policy. However, we expect the chilling effect to extend to programs and services that are not named in the rule, particularly in light of the broader immigration policy context. State and local agencies, advocates, and researchers should monitor program data to identify unexpected changes in enrollment in order to document the broader impact of the final rule and other policy changes on families and communities. For example, the Georgetown Center for Children and Families has been monitoring Medicaid and CHIP enrollment and has seen a decline in enrollment among children for the first time in nearly a decade. Other researchers have also documented a decline in SNAP enrollment among recently arrived immigrant families after 10 years of increasing participation. And we've also heard reports from researchers who are looking at WIC enrollment and finding that many WIC providers are experiencing a decline in enrollment, some up to 20%. Direct service providers should also document instances where immigrant families share fears about public charge. In doing so, you of course want to remain cautious about protecting families' privacy. If you're an early childhood program and you're noticing any changes in enrollment or changes in attendance, class would really love to hear from you. We're trying to document the impact of public charge and other policy changes, and I encourage you to reach out to me if you have any stories that you'd like to share. My email will be at the end of the presentation. Next slide. So we'll move into the Q&A in just a minute, so please continue sending your questions in the chat box. But before we answer your questions, we wanted to share a few particularly important things to remember from this webinar. The core messages will also be important to keep in mind when you're talking to immigrant families about public charge. First, the public charge test does not apply to every immigrant. Refugees, asylees, survivors of trafficking or domestic violence, and other vulnerable populations are exempt from public charge determinations. That means benefits received when people are in one of these statuses will not be counted against them. And lawful permanent residents are not subject to a public charge test when they apply for U.S. citizenship. Second, the rule does not consider benefits used before October 15th, 2019. Benefits that were previously excluded from the public charge test, such as Medicaid and SNAP, will only be considered if they are received after the final rule goes into effect. Until October 15th, the only benefits that will be considered in public charge determinations are government-funded long-term care and cash assistance. It's also important to keep in mind that the use of public benefits alone will not automatically make someone a public charge. Immigration officials must look at all relevant circumstances in determining whether someone is likely to become a public charge in the future. Public benefit use is just one of those factors. Especially important for all of you working with families with children to keep in mind is that the public charge test does not consider benefits used by one's family members. Most immigrants who are applying for a green card are not eligible for the benefits listed in the rule. Benefits used by eligible children, including U.S. citizen children, will not be considered in a parent's public charge determination. Immigrant parents can continue to access benefits for their children without consequence to them in a public charge determination. Changes to public charge policy also do not affect eligibility for public programs and services. Eligibility rules are encoded into law and cannot be changed by this administrative action. And finally, families' personal information is protected when they are applying for public benefits. Federal and state laws protect the privacy of people who are applying for or receiving healthcare, nutrition, economic support, early care and education, and other public programs and services. And finally, truly finally, the fight is not over. Advocates are using every tool at their disposal to stop this rule from taking effect, including in the courtroom. Already, there have been 6 different lawsuits filed in opposition to the final rule. We still have a chance to stop the rule from moving forward. Next slide, please. All right, so a few of you have submitted questions into the chat box, and we encourage you to continue doing so as we begin to answer questions. The first question is about whether the public charge rule will affect immigrants when they're applying to college or applying to access financial aid. So I'm going to let Renato answer that first question.
So thanks for that question. So no, public charge will not affect someone applying to college or for financial aid. Financial aid and student loans have no bearing on public charge determinations. This is the case for immigrant students themselves who are applying for financial aid in college and student loans, and they may, pursue to apply for a green card, so that's not the case for them. And once again, there are no public charge consequences for the parent of a student applying for financial aid. So, in short, public charge will not affect someone applying for financial aid to go to college.
So we also got a question about mixed status households where there might be a child who is ineligible for benefits that's part of the household, but the benefit is prorated, and the person is wondering how this will be parsed out. So without knowing kind of specifically the circumstances, we'll just remind you that children's use of benefits doesn't have any bearing on a parent's public charge determination. And in any public charge determination, immigration officials are only looking at benefit use by the person in question. So in mixed status households where one child might be a citizen and another child might not, decisions should really be made on a case-by-case basis if it's a household benefit. And again, we really encourage you all to make connections with legal service providers so that you can provide a warm handoff and help families get kind of more specific advice around their particular circumstances.
So we received a question that's asking to help explain in a bit more detail the overlap between populations that are eligible for a benefit and those that would or would not be affected by the public charge test. So I will I'll share an overlap of SNAP specifically. So as we said a little bit earlier in our presentation, lawful permanent residents who leave the U.S. for more than 6 months and attempt to re-enter can be subject to the public charge rule. And these legal permanent residents may also be eligible for SNAP, for instance. There are also other categories of immigrants that are eligible for SNAP and may also go through a public charge determination, including some immigrants from the Hmong and Lao community that helped during the Vietnam War may be subject to a public charge test. In terms of some immigrants that may be eligible for programs and would not be directly affected, this is what we're describing as chilling effects. So this could be, for instance, a family where all members of the household are citizens, either naturalized or U.S.-born citizens, because of fear and confusion with public charge and other harsh immigration actions and rhetoric by the administration may be worried about accessing some public benefits. And even these households where each member could be a citizen and eligible for public benefits could either decide not to apply for public benefits or withdraw from public benefits due to this fear and confusion, and they're essentially being chilled from accessing these benefits. And I'll quickly cite here, and we'll include this resource in the follow-up, but the Urban Institute recently came out with a study that looked at the chilling effects that are already happening in 2018, and they provide evidence of the chilling effects that are already happening, including in families where the public charge test wouldn't directly be applied.
Yeah, and so just in general, something to keep in mind is that the vast majority of immigrants who might be going through a public charge determination are generally not eligible for the benefits that are listed in the rule. And like Renato said, there are some exceptions to that. But in general, there is not a ton of overlap between eligibility for the benefits that are listed in the rule and people who would be going through a public charge determination. But what they're looking at, what government officials are looking at is not just whether folks have used the benefits in the past, but whether they're likely to use any of these benefits in the future. And so even if you have never used a benefit before, the question that they're asking is, are you likely to use one or more of these programs down the line? And that's why this is such a concerning and expansive change in policy from how it has been implemented for a long, long time. Let's see. So we've also gotten some questions about so we have a question about whether child care assistance or state pre-K would affect families' public charge determination. And again, the answer to that is no. So the only benefits that are non-cash benefits that are included in a public charge determination are those that are explicitly named in the rule, and that's SNAP, various types of housing assistance, Medicaid with exceptions for emergency care and children and pregnant women, and government-funded long-term care. And so if any other non-cash benefit wasn't named in the rule, then it's not going to be included in a public charge determination. So child care assistance is okay to use, and state pre-K is okay to use. But also, I'll remind you that in general, the people who are using child care assistance or who are enrolling in state pre-K, those programs are for the child. Like the child is considered the applicant for those programs in general. And so given the characteristics of young children in immigrant families, the vast majority of them are U.S. citizens, so they wouldn't be going through a public charge determination in the first place.
So we have one question about how public charge may affect DACA recipients. And the question is asking whether this means that they can't access these benefits after October 15th. So DACA recipients may eventually apply for a green card through a variety of different options. Therefore, really, they could be subject to the public charge test at some point in the future. And if the changes go into effect on October 15th, they would also be subject to those changes if they apply for a green card after October 15th. So once again, they should consult with a lawyer, if possible, regarding decisions of benefit use included in this rule.
So we also got a question about how the inclusion of government-funded long-term care would affect special needs children. So I'll remind you that the inclusion of government-funded long-term care, that has been in the rule for a long time. So that is not a newly included program. And when we say government-funded long-term care, we're basically referring to institutional care at the government's expense. So of course, individuals with disabilities are disproportionately likely to need that kind of care. However, that has been part of the law for a really long time. So children with special healthcare needs or with disabilities who need to use Medicaid or who need to use early intervention or other special education services, none of those services would be affected. So Medicaid's named in the rule, but there is an exclusion, an exception for children who are under the age of 21, so they can continue to use Medicaid without consequence in a public charge determination. And then programs like IDEA are not included in the rule. So again, those programs would not count in a public charge determination either.
So there's a question about how your organizations may get involved in stopping this rule. We had the link in the slides, and the slides will be available after the presentation. But I would say get involved with the Protecting Immigrant Families campaign. You can visit protectingimmigrantfamilies.org, and there is a tab at the top right of the website that invites folks to get involved with the campaign. And you can, get involved with working groups. You can get involved with weekly newsletters and stay up to date on information, including some of the progress of litigation that's taken place, how research is documenting the chilling effects that are already happening in communities, what organizations can do to advocate for their community with their members of Congress, and how potentially your communications team may want to talk about public charge with members of your community and with the larger public. So, if you would like to get involved more on this topic, I highly encourage you to get involved with the Protecting Immigrant Families campaign.
So someone asked, said that they have heard that a couple people have mentioned that they're concerned that the Trump administration officials will not follow the rules as they're written, and asked if this was something that we have heard concerns about and if there's any advice on how to address it. And really, the best way that we can address these types of concerns is by empowering families with the best and most accurate and up-to-date information possible, and documenting bad practice. And the impact of the rules so that we can fight back, again, including through litigation. But I think it's important to underscore that when communicating with families, obviously we want to make sure that they have the best information available to them, and sharing accurate, up-to-date information is really key. But I also think it's important to share and let families know that there is a, kind of whole host of organizations and lawyers and advocates who are really working hard to fight back against the implementation of the rule, and who are working hard to make sure that it never goes into effect, and that we, try to mitigate the harm in the meantime as much as possible. Just to let people know that they're not alone, that people are really committed to protecting their safety. And then someone also asked a clarifying question about whether undocumented pregnant women who utilize emergency Medicaid, and whether they would be subject to public charge. So if a person, if an undocumented woman eventually hopes to get a green card, their use of emergency Medicaid would not count in a future public charge determination, because emergency Medicaid is excluded from the types of benefits that are considered in a public charge determination. And then there's also the exception for pregnant women, so there's sort of a doubly they're not counted either way, both because of their the program that they would be using, and also because they were pregnant at the time.
So there's a question about whether SNAP benefits on behalf of a U.S. citizen child would affect a potential green card application or public charge determination of the mother. And just to reiterate, the use of benefits by children, does not come into play of their parents' public charge determination. And we've also received several questions about whether this slideshow will be available. And this slideshow will be emailed to everyone that's registered, and it will be made available after this presentation.
Thank you for your patience. We are just going through some additional questions. Okay, so someone asked whether applying for healthcare coverage through a state healthcare exchange, if they are screened for Medicaid eligibility, whether it would be considered an attempt to use non-emergency Medicaid services and weighted negatively in a public charge determination in the future. So based on our best interpretation of the rule, we would not expect that kind of screening to impact a public charge determination. It would be benefit use that would be a heavily weighted negative factor in a determination in the future.
So we received a question to repeat the impact data of the changes to public charge, so the final public charge rule. So Manat Health estimate that approximately 26 million people would be potentially chilled by the public charge rule. And this number includes individuals in families with at least one non-citizen and households with earned incomes under 250% of the federal poverty level. And of that 26 million total potentially impacted population, approximately 9 million are children, the vast majority of which are U.S. citizens.
And if you're interested in finding the estimates for people who might be potentially affected in your state or your community, we definitely encourage you to check out the Manat Health dashboard, which you should be able to find a link to on the Protecting Immigrant Families webpage, which is www.protectingimmigrantfamilies.org. You can also find a few state-by-state fact sheets that demonstrate the potential impact of the rule on the PIP campaign website as well. So we also have a question about state-subsidized housing and whether that would be considered in a public charge determination. It will not be. So again, the only non-cash benefits that are included in a public charge determination are those that are explicitly named in the final rule. And state-subsidized housing is not listed in the rule, so it would not be included in a public charge determination.
So we have a question that asks whether if a child receives benefits, whether those benefits would count towards a child's application for a green card once they're an adult. So as a reminder, the use of public benefits by a child is counted for their own green card application in the future. I'll note here that there are exceptions for children in the use of Medicaid, and the way that and the final rule, says that only benefit use after the rule goes into effect on October 15th would count. So just wanted to clarify that use of public benefits would count for the applicant of a green card.
So we also got a question about whether there's any information or evidence that this chilling effect that we're talking about is sort of the purpose or the intent of the new rule, and whether there's sort of an intentional effort to cause fear and confusion. And so that has not been explicitly stated necessarily. However, I think we can point to the Department of Homeland Security's own estimates of the kind of potential fallout or the potential implications of the public charge rule, and their estimates of kind of how they went about calculating cost savings as a function of the proposed rule. So the Department of Homeland Security, in its own assessment of the rule, anticipates a significant chilling effect. They anticipate that it's going to be a large share of whom are U.S. citizen children who are going to be affected by the rule. And in fact, when they are calculating their cost savings, so when they're saying how they're going to save money by implementing this rule, disenrollment from these programs by U.S. citizen children is kind of effectively the foundation of how they're going to save time or save resources. Because again, as we said earlier, the vast majority of people who are actually going to be applying for a green card and going through a public charge determination are not actually even eligible for these benefits that are named in the rule. So by and large, the savings that the government will receive by people disenrolling are going to be from eligible family members, which is the result of this kind of fear and confusion, a result of this chilling effect.
And just to quickly repeat, the number of children that would be chilled is estimated at 9 million. And this number comes from Manat Health and represents individuals and family members with at least one non-citizen in the household and who live in households with earned incomes under 250% of the federal poverty level. So those are the children in these families, moderate to low-income immigrant families that could be chilled by the final public charge rule.
And the reason that they use that 250% poverty threshold is because, well, A, that's, people who are under that income level are folks who are generally eligible for these programs. But it's also because that the only positively weighted factor in a public charge determination is having an income over 250% of the federal poverty threshold. So again, the rule is really targeting low and moderate income immigrants. All right, and with that, I think we have gone through the questions that we've received so far. If you submitted a question that we didn't answer today, please don't hesitate to get in touch with us. Next slide, please. So here is my contact information as well as Renato's contact information. Like I said, if you have additional questions, please don't hesitate to get in touch with us over email. As a reminder, we're going to send a link to the webinar recording to everyone who registered. With the recording, we'll also share some of the resources that we mentioned during the webinar, including a document that talks about changes to the Foreign Affairs Manual, a document that discusses immigrant eligibility for public benefit programs, as well as a resource that talks through the kind of specific privacy protections that are included in different federal programs that might be useful for all of you in your work with families with children. I also encourage you to keep an eye out for an upcoming resource from CLASP, a Q&A on public charge that is specifically for early childhood stakeholders. The Q&A will include information that we shared on the webinar, plus it'll answer some additional questions for early childhood advocates, providers, and policymakers. So again, we thank you so much for joining us. And we look forward to your continued partnership as we work to fight back against this rule.
Thank you very much.